Hello, may it please you, and welcome to the second in a series of sports law webinars with Outer Temple Chambers and Irwin Mitchell. I am Weston, I'm a barrister and I head up the sports law group here in Chambers. But today I'm very much the compare and the contrast in a webinar which is focused loosely on the topic of women in sport, sharing experience of athletic participants and a sports regulator and addressing some legal concerns. Because this is a Zoom meeting, it is being recorded. And whilst I will ask some questions, you're all very much welcome, please, to enter any questions you have in the Q&A box, which you'll see at the bottom of your Zoom page. So less about me. Let me introduce, please, our speakers in order of reverse appearance. We have a barrister in Chambers, Sophie O'Sullivan, a business and crime specialist with a very impressive catalogue of cases in disciplinary and regulatory proceedings, which is a very modest way of saying, I think, that she's a very accomplished advocate with a keen forensic mind who will be addressing for us safeguarding and special measures in sports law proceedings. We have from across the Irish Sea, Cliodhna Guy, who is the head of legal at the Irish Horseracing Regulatory Board, which body governs the beating heart of racing on the island of Ireland. She was recently the mind of the regulator dealing with the Gordon Elliott case, which was of unpleasant photographs of dead horses. And she will tell us about her path and rise to the top in sports law governance. Third, my head of chambers, Sarah Crowther, Queen's Counsel, leading silk in public and human rights law, and now deploying those skills and that expertise in safeguarding and governance cases. She describes herself on Twitter as a former barmaid, and so she has all the skills necessary to work at the bar, keep your regulars happy and welcome new clients with open arms and a smile. She'll be addressing equality in sport and what that may mean in the context of concussion. But our first speaker is an athlete. She is Kylie Hutchison, Senior Associate in the International Travel Team at Irwin Mitchell. She works by way of her day job, so to speak, on catastrophic and mass injury cases, principally arising from incidents overseas. And aside from that, she has more than 122 caps representing England in the sport of touch rugby. And if you pause just for a second, that's more caps than Harry Kane, more caps than Owen Farrell, it's more caps even than Joe Root. And it's more than any England woman test cricketer, and yet you may not have heard of her, and she may not be populating the back pages of the Sun newspaper from time to time. But she's here to talk to us about her experience as an England player and balancing the life in that sport with her very successful legal career. So, hello, Kylie.
Hi, Louis. Thank you very much for that very generous introduction.
Well, you paid me. So let's ask you some questions. Tell us, please, a bit about yourself. Tell us who you are legally.
Yeah, so I'm originally from Australia. I was admitted as a solicitor there in 2000, came to England a couple of years after that, gained qualification in England and Wales in 2006, and have been working pretty much most of that time at Irwin Mitchell. I'm now Senior Associate in the International Travel Team. I specialise in cross-border complex injury claims, and over the years I've acted for claimants and defendants in claims arising from all sorts of accidents in cars, boats, planes, hotels, animals, medical negligence, sport, which is a particular passion. And I'm currently running a large group action representing 85 claimants in a claim arising from the Tunisian terrorist attack in 2015.
So, if I may flatter you a bit more, for many of you, a fairly high-powered and busy legal career, yes?
Definitely busy, yes.
Okay, but you also manage, I think, to sit on a sports disciplinary panel, the RFU London disciplinary panel?
Yes.
So you do some work where you sit as a judicial type officer in on-field disputes mostly, is that right?
That's right, yeah.
Okay, now that's the side of your life that we knew in Chambers, but aside from that, you have something of a sporting career. So tell us about the sport first. What's the sport? Yeah,
so the sport is touch rugby. It's a massive sport in the Southern Hemisphere. It's lesser known here, but is growing. It's a summer sport which was invented in Australia to keep players fit during the sort of off season. And there are now actually more players playing that in Australia, then rugby league and rugby union combined. I have been playing for touch for England for the last 17 years, which is slightly ironic being Australian. The game itself it's probably a bit more like rugby league, where you get 6 touches instead of tackles, so it makes it less physical, but it's a much quicker game. We play on slightly smaller fields than a full rugby pitch, but there are only 6 players on the field for each team at a time, so it's a bit more like sevens with space. And when you're on the field, you're pretty much going at full speed, but you can sub on and off as much as you like. And if you've got the ball, you can initiate the touch, so the attacking team can dictate the terms of play, and you sort of have to use your touches wisely, manipulate defenders, and you can't just bulldoze through, which makes it quite tactical, and you need to think about it, which is what I really enjoy about it.
In Australia, is it a sport that's played at all age ranges and across all genders?
Absolutely. You tend to start really, really young, and there's age categories up to over 60s and things in some of the divisions. So it's at all ages. You can play mixed as well. Quite often there's mixed games where men and women play together. But it's massive down under, and getting slightly more so here, but there's still a way to go.
And having adopted what appears to be the English talent of remembering people's heritage, how did you come to start playing for England, and how many caps have you achieved there?
Yeah, so I initially had an ancestry visa, and so became eligible to play for England at the European Championships in Jersey in 2000. And I was in the England Women's Open team until 2018. And one of the good things, as you say, is you can play in all the different age grades. And for England, we've got women's over 27s and over 35s. So the last couple of years, I've been playing, or probably more accurately, dragging myself around the field and for the women's 35s. So yeah, I've played, as you say, 122 odd caps. I've probably lost a few along the way. The event has to be sort of officially sanctioned by the Federation of International Touch to count. But the record books will say my 100th cap was during the final in 2016 for the European Championships, and it probably couldn't have been scripted better. I led the team out as captain. We won. We continued our unbeaten record in Europe. The Welsh team voted me the player of the match, entirely to do with the milestone, not because of the way I played, but it was still very nice of them, given the sort of fierce rivalry that we have over the years. I've played in 4 World Cups, 8 European Championships, quite a few other home nations and other tournaments. I think I'm currently the only English player to have reached 100 caps. There are a few closing in. At the time, I was the only worldwide player to have it all, 100 caps all in the Opens. A Welsh woman has now achieved the feat as well, but there are quite a few that have got 100 caps in sort of different age ranges or coaching and playing as well.
So 4 World Cups. So in most professional sport, everyone would have your name on the tip of their tongue. But do I get the picture that you don't spend a lot of time being driven through hordes of press reporters and pushing back the media appearances at these? Whether these World Cups take place? Yeah.
So the first one was in South Africa in 2007, then 2011 with Scotland, 2015 in Australia, and then the last one, 2019 in Malaysia. So you've been to some wonderful places. We'll come back to you. But is your playing career reaching its end, or do you think you have a few more, what would I say, matches, years, tournaments? Yeah, I'm hoping, all being well, to play in the next World Cup. But we'll have to see how I go. I'm definitely slowing down, and the body's not quite as cooperative as it has been. So we'll see. I'll play for as long as I can. Look at me. When's the next World Cup? So it is due in 2023. So hopefully COVID will be gone by then, and it's all still happening. But we've lost the European Championships last year and this year. But yeah, hopefully the World Cup's still a go. And aside from the playing, are you involved in the sport in any other way? Yeah, I do a bit of coaching, and also help with the England Touch on a sort of high performance consultant, sit on the coaching selection panels and things like that, and actually help with the discipline side of things once that's all up and running too. No, good. So it's a sport that's learnt from the experience of its participants rather than just sort of leaving them out in the cold and forgetting who they are. Yeah.
And do you have a role in the TV coverage of the sport? Have you become a commentator or on the radio side of it, anything like that?
No. We do have occasional live streaming of games, but no, not yet added that to the list.
Let's go back to how do you balance this? How much time do you estimate you spend in preparing for tournaments and practicing and training? How do you manage that side of it? How much time does it take up?
Yeah, I mean, obviously it's an amateur sport, but it does still require a high level of commitment. We have the World Cups every 4 years, European Championships every 2 years, and then there's other tournaments sort of interspersed with that. Domestically, there's like a national championships, which acts as a selection path. So pretty much every weekend, and you have club as well, and a Super League on a Thursday. So I've got something on generally several times a week, match wise, and then nearly every weekend over summer. Our England squads train sort of once a month all year round. We have full weekend camps all over the country, and they'll include things like games, fitness testing, sessions on sports psychology, diet, video analysis. You also have club and regional trainings. And then on top of that, there's quite a lot of individual training. We get strength and conditioning programs. You've got to work on a lot of technical skills yourself, like passing and understanding of the game. So I have spent hours studying sort of playbooks, videos, making notes, trying to understand moves and tactics and things like that.
And what about things like sports psychology and diet? Do you have to sort of maintain a regime at home? That's what's holding me back.
Yeah. I must admit, training has sort of changed for me a bit over the years. When I was younger, it was much easier to sort of stay on top of that, keep fit and that sort of thing, and you just get injured less and less responsibility at work, so it was easier to balance. And I used to keep fit all year round, but now I operate a bit more differently, a bit more strategically, sort of approach things in a bit of a targeted way. So there's normally one big event in a year. So in the lead up to that, I really prioritize training and probably do follow all the diets and all that sort of stuff that you're supposed to do in the lead up to a tournament. In the off season, work is probably more my main focus. So at times I'll be doing sort of bare minimum to keep ticking over. But I guess in saying that, probably not a day goes by where I'm not doing something connected to touch, whether it be training, rehab, studying, planning. Although I've got to say I have been pretty terrible during lockdown without any sort of tournaments in the diary to work towards.
And it's a non-contact sport, but have you suffered any sporting injuries or?
Yeah, I mean, on the whole, I've been pretty lucky with injuries, but yeah, of course, I've had a few. I've probably injured most body parts at some point during the time. I think I've had sort of fractured ankle, dislocated finger, split webbing on my fingers, lots of soft tissue injuries, bruising, torn muscles. There was a point where I was a bit worried about what my sort of Birmingham colleagues thought of me, who I don't see very often. I turned up to one of our get-togethers with a black eye, and then the next one I had a fat lip. But unfortunately, those sorts of injuries are pretty rare, and I've got health insurance through my work, so benefits package. That's been a bit of a lifesaver too. But yeah, all in all, pretty lucky, I would say.
And those injuries, I understand that touch rugby you can play mostly same sex, but occasionally there's mixed matches. Is it when you've been playing with men that you suffer the injuries, or is it more aggressive women? How does it work?
No, I think it's probably the latter, actually. I think probably, yeah, more Rangers have been playing in the women's game than they have mixed. I would think, yeah.
And how have you found? I mean, it's difficult because you're employed by them, and some of them are watching, no doubt. But how have you found your employers, Irwin Mitchell's approach to your going off to do all these sporting endeavours?
Yeah, I think I've been really lucky to have extremely supportive employers. One of my first major tournaments was an All Nations in New Zealand, and Irwin Mitchell sponsored me and gave me some funding towards that trip, which I would have really struggled without. And they've also been really flexible with leave. And I've had teammates who haven't been so lucky, teachers and things who have massive battles to try and get time off work, and we've probably lost some good players over the years too, who just can't invest the time and resources needed. So I've been really lucky in that respect.
And I said at the outset that you have more caps than the three sort of most famous sportsmen in England, and many sportswomen too. Do you think your sport gets the recognition that it deserves?
No, probably not. I think most athletes don't participate in sport for the plaudits. It's the thrill of the competition. But it would be nice to see my sport and women generally, be celebrated more. I think when you think of how well known Gary Lineker is versus a Kelly Smith who has more caps and scored more goals, it's nice for young girls to have those sorts of role models more visible. I have played with some amazing athletes in my sport, not me, but there are some whose fitness tests are on par with really top professional athletes, and the level and commitment from a lot of my teammates is phenomenal. In addition to having careers, some of them have 3 or so kids and single parents, and it is really, really inspiring.
And does the sport make it easy? I mean, does it treat men and women's sides of the sport of touch rugby in the same way? Have you found any advantages within the sporting context?
Yeah, I'd say touch is a great sport for inclusivity. We do have competitions of all ages, and mixed sex can play together. And I'd say it is one of the better sports in terms of equality. And England Touch, I think, are currently advertising for a qualities, diversity and inclusion officer. But even in saying that, it's not perfect. At tournaments, referees are ranked, and the best referees are generally assigned to the men's games. Same with coaching. The top coaching job is regarded as the men's open, and we have a disproportionately low number of women coaches. And in fact, I don't think there are any head coaches in the adult program at the moment that are females. Like for tournaments, there'll be a large number of playing fields. The best quality field is always designated field 1, a bit like centre court. And most of our tournaments are live streamed now. And the organisers try and make sure everyone gets a live stream game. But last Euros, we had 1 game, whereas the Men's Open had most of their games on it. And I think I've had probably similar experiences with training fields and facilities and things like that. So there's still a long way to go in my sport, and probably even more so in other sports. And we hope that advancement in professionalism and participation in women's sport will continue to improve. But I think with my kind of lawyer's hat on, there are some injuries that women are more susceptible. Concussion being a hot topic at the moment, knee injuries, that sort of thing. And if women aren't getting the best coaching from an early age, learning the correct techniques, not having the best referees, equipment, access to medical support, etc., it does make it an increased risk. And I think I've felt that sort of trying to balance competing interests with work. There are times that you can't do it all. And for me, if I have to drop a training session, it would be what I least like to do, which is probably like a weight session. So, but obviously, if you do that a lot, you don't have the solid foundation, and that can also lead to increased injury as well.
Do you think, standing back, you're not at the end of your career, you're still running through it and still on the up as far as I can work out. Do you think that touch rugby has been a benefit to your legal career?
Yeah, I think it's probably impacted on my career in terms of I've probably not been as ambitious career-wise as I could have been, whereas with touch, I sort of very focused in goal setting, know what I want to achieve and set out what I have to do to get there. And I probably haven't done that with sort of trying to get promotions and things like that. But, I want to be good at my job and do the best for my clients. And I'm, pretty content with that. But I think having adopted that approach and just being reliable and hardworking and having some transferable skills, I still have naturally progressed. So, yeah, I probably wouldn't change anything that where I'm at.
And what have been just 2 or 3 highlights from your career as a sportsman, mixing it with law?
Yeah, I think it's probably easy to look back and think that it's sort of unfair that I didn't get the same opportunities as to pursue a career professionally, and I've had to do the 2 things sort of side by side. But I think that's actually been a real benefit, and playing sport has made me really more rounded as a person. And if work has been quite stressful, it's great to have an outlet to go and let off steam, and work is a good distraction if you lose or are injured. Just participating in the World Cups have been a massive highlight. In the 27, we just missed out on a bronze medal, and I was sort of in peak condition for that. So I was really devoted to 2011 was going to be my year. I was threw everything at it. Wasn't feeling as a fit though. Decided to up the ante on my training and do some extra running in the morning in addition to the stuff I was doing in the afternoon. And then at that tournament, tore my calf muscle in halfway through. So if I had sort of built everything up for that moment, and would have been absolutely devastated if that was my sole career. That's all I did. It probably would have broken me. But I was back at work the next week, seeing clients with life-changing injuries. So it just complete perspective. And I think just having that balance has really, really been a highlight. And I've had skills that I've been able to transfer over. I think I've been able to play probably as long as I have due to the sort of analytical attention to detail type skills that have, I'm certainly not the quickest or most athletic player, but it's the reading the game, the understanding of it, that's really allowed me to have quite a long playing career. I think there've definitely been some benefits in trying to balance. Like most women, you sort of need to do more with sports and families, and it just means you become quite adept at planning, organising, prioritising, and coping with pressure. So that's been a real positive from my perspective, in that when you have to work hard and make these sort of sacrifices, it does really make the result more satisfying. And last World Cup, we ended up with a bronze medal, so that's sort of been the absolute highlight.
Well, I'm pretty much in awe of you, and I'm most in awe of the fact that you can say with a straight face looking at me that you're not the quickest or most athletic lawyer. We're going to pick up on a topic that you raised, which is even though touch rugby doesn't involve people of my size banging into each other at speed, you do suffer concussion injury. And one of the questions in sport is, how do you manage a concussion injury in that way? So without more than that, hello, Sarah.
Hello, thanks Louis, and thanks for the very generous introduction as well. So it's a shame that we're remote, otherwise I'd offer to go down to the nearest pub and I could demonstrate that I've still got the ability to pull a fairly decent Guinness, but maybe we'll have to do that on another occasion when we're all in person. I was going to talk for a little while about picking up on something that Kylie mentioned, which is about health and safety of women participants in sport, and really to pose a question, which is whether the same treatment for women as for men, particularly in respect of concussion injury risk, is actually going to deliver equality, and whether actually that's enough for governing bodies and sports organisations to fulfil their duties of care to women athletes. I should preface what I've got to say with a bit of a kind of nomenclature definition. I know that there is a lot of at times heated debate about who qualifies as a man or a woman for participation in different sports, but I haven't got time to get into that interesting topic today. So if I talk about men and women or males and females, I'm looking at it solely from the biological perspective at the moment, without addressing the even more complicated issue of transgender individuals or intersex individuals and their participation in different categories. But it has been a topic, concussion, that has drawn a lot of media attention lately. I mean, many of us will have seen Will Smith's movie Concussion, and recently I watched what I thought was a particularly moving documentary on the BBC of Jack Charlton, the footballer and Ireland manager, which personally I thought was beautifully put together, but it was also a very insightful kind of illustration of how devastating traumatic brain injuries can be for sports people. But of course, men playing football are not the only athletes at risk. Although historically, interestingly, women players were thought to be less prone than males to concussion. And one heroine of my story is a lady called Tracy Kavassin, who's at Michigan State University, who seems to be on a kind of one-woman kind of mission to collect data relevant to this question. And she published in 2013 a study that showed that rates of concussion in female athletes had surpassed that of males, and also that the resulting brain injuries tend to be more severe. And as we know, concussions occur in one of two ways, and those of you who are personal injury lawyers and read plenty of neurological medical evidence will know this already, but although you can get concussion from a direct blow, so if you hit an object or another person, you can also get concussion from an indirect blow, a little bit like when you have whiplash in a car accident, because of course the brain is soft inside the skull and it continues to move even after the skull hasn't. And that kind of injury triggers then a metabolic cascade because the brain tissue stretches And what we have learned through the medicine is that the brain effectively needs to be rested until those symptoms resolve and given a chance to recover. But most sports where female athletes participate have identical rules of participation, identical rules for identifying head injuries and concussion. And I just pose the question as to whether in this day and age, given what we know about the difference, which I'm going to come on to discuss, whether that is actually adequate, and whether it might be said that governing bodies and sports organisations ought to be developing their own specific rules in respect of the risk towards women. Now, there've been particular reasons that have been suggested why women might be more vulnerable to concussion. Women tend to have longer, narrower, less muscular necks, and we also have a smaller average head size than men. It has also been suggested that the female brain itself is more predisposed to symptoms of concussion injury, and there is some support for that in the studies as well. But none of these findings are without controversy, and in any area where it's suggested that there might be a sex-related divergence, it's not long before some bloke comes along with a sexual stereotype in order to seek to explain it away. And it's true in the case of concussion as well. And some male scientists, it has to be said because they were male scientists, had suggested that the reason that there were higher figures for female athletes having concussion than men is because women are simply more likely to self-report the symptoms. In other words, the tough guys, they just get on with it and they don't say anything. And it's all you girls having a bit of a whinge. Now, for me, that also raises questions in the context of duty of care, because it has also been shown in other contexts that when women do report symptoms or abnormalities in a medical context, they can be disregarded or minimised. And I think something that sports organisations and medical governance teams need to be alert to, particularly when data is coming from fields that are male-dominated, such as the medical profession and indeed sports governance itself, is that we need to be very careful that the impact on women is not either consciously or subconsciously minimised. Happily, there are many scientists who are not deterred by that kind of attitude, and we can see from later studies that have emerged that there is indeed a sex-related difference in concussion symptoms. And there's one particular study by Broshek which uses computerized neurocognitive testing in order to get around the women just complain about it more problem, and that demonstrates objectively, as well as based on symptomatic report, that males and females have both a different pattern of neurological symptoms, but also that the symptoms tend to last longer and be more serious in females, who are more likely to have loss of concentration, fatigue, fly spots in vision, and lightheadedness, and poorer performance on neurocognitive tests. And if we move forward to 2021 and our hero from Michigan again, she's now collected data from some 80,000 female soccer players in the US system, which has revealed that they're nearly twice as likely to suffer concussion as their male counterparts. So it's a striking difference in terms of both the risk and also the severity of the consequences. And the other feature from that study that struck me as interesting was that the manner in which women tend to suffer concussion injuries is different. Girls were more likely to have concussion from collision with an object, such as the ball or goalposts, whereas boys are much more likely to incur injury in collision with another player. And that kind of rang a bell for me, that a lot of the talk about concussion is focused on contact sports, where one thinks about the concussion being the moment of the tackle or the impact player on player. But it just demonstrates that there is a need for education, in my view, about the fact that women concussion risk arises in a slightly different way out of their sporting activities. The other, before I move on, final interesting point from that study is that they also looked at what happened after a concussion injury. And apparently boys are much more likely to be removed immediately from play after a head injury than girls are. Girls are actually more likely to be encouraged to carry on even when it was inappropriate to do so. And again, I'm warming to my theme now, but it makes me wonder a little bit if sometimes when girls complain of cognitive symptoms, it tends to be downplayed. So what can we do, or should we do, to address this sex-related divergence? Well, it seems to me there are a few areas that we can look at. I mean, a key one is going to be education of parents, players, coaches, recognising not just the symptoms of head injury and concussion once it's occurred to mitigate it, but also the risks and the situations in which head injury might occur. And it was striking at the recent evidence that was given by the FA to the Parliamentary Committee, the Digital Culture, Media and Sport Committee, that the FA says that it doesn't have any particular plans to have women-specific considerations on concussion. There is touching reference to it, passing reference to women being more at risk in their concussion guidance, but it doesn't actually set out any of the data that we do know about when those risks arise and in what way they're different and how women's head injury might present differently. So that's an area where it seems to me a lot more could and should be done. A second area that needs to be looked at, in my view, is data collection. And obviously they've done great things in Michigan. There is some work now being done in the UK. There's a project called SCORES Project, which is looking at dementia and other concussion-related risks in sport. And they've got a dedicated stream looking at sex-related divergence between men and women in this field. And part of what they're trying to do at the moment is to collect data from athletes who have had long playing careers and do not yet have any symptoms whatsoever, but to collect data from them about concussions and traumas and impacts in order to have a better data set to work from. And the third area that obviously I've touched on already is the question of the rules of the game. And at the moment, most sports will have identical sets of rules for men's and women's games. We're already beginning to see differentiation in rules of the game in respect of children's games in terms of football and the elimination of heading the ball. And we know as well that the NFL have got their framework, which reduces radically the amount of contact in training. But it does seem to me that further thought needs to be given to the women's game of football and whether heading of the ball should be routinely permitted in training, whether there ought to be other training restrictions about contact and tackling, and how much physical contact is actually required. And then there's some good old-fashioned discrimination issues that need to be picked up in terms of mitigation. Another thing that came out of the evidence to the DCMS recently is that the requirements for medical assistance at pitch side are much less in the women's game than they are in the men's game. So, for example, while in the men's sport, there's need for 4 medical practitioners, including the so-called tunnel doctor. And I know that's a controversial character, but the one who watches the video in real time to try to work out what the concussion might have been. At the women's game, there's only need for 1 clinical practitioner to be on pitch side. And even taking into account the financial considerations and the fact that obviously there's not as much money in the women's game, it does seem to me that when you're looking at something so important as the health and safety of the participants, it does seem a little bit astonishing that there's such a major differential between the men's and the women's game in an area where we know from the statistics that women are actually more at risk. So those are the things that I think could be done now. I mean, if one were being super grand about it and thinking on a kind of much broader scale, I mean, maybe this is an area in which increased harmonisation of approach between sports governing bodies could be adopted. I mean, it's been very successful in doping, for example, to have a kind of harmonised approach to risk management and also to enforcement. It seems to me there's no obvious reason why something similar couldn't be done in this field as well. And longer term, really, there ought to be financial provision and safety netting for those participants who, sad to say, it seems likely will go on in future to suffer from CTE and other similar brain conditions as a result of sustained traumatic injuries over the years. But those are possibly future considerations that fall a little bit outside the remit of a mere personal injury lawyer like myself. But those, it seemed to me, would be the kind of starting points for dealing with this. It's a big topic to tackle, but at the same time, it's one in which we've now got a lot of data, and I think action needs to be taken sooner rather than later. So I should get off my hobby horse now and shut up, Louis, and find out what you think.
I never have any positive thoughts, so I managed to keep myself on mute. Great success there. I do have a question there, which is this: that in Kylie's sport of touch rugby, where you have men and women competing in the same sport at the same time, are there equality law concerns and a different protocol for women and a different protocol for men, that one or other side of that particular fence might get dischuffed by it all?
Well, I'm not sure. I mean, if you had a mixed sex game and you applied the same rules to everybody, I think if those rules were justified by the need to protect participants of a particular category because they're women, I find it difficult to see how that is discriminatory. There would be the same rules for everyone. I mean, probably what it would mean. I was thinking a little bit about this. I mean, what you could have restrictions on tackling or contact. I mean, that's not particularly an issue in your sport, Kylie, but you could also think of other sports where that would be particularly useful, hockey or football or I've played quite a lot of mixed hockey in my time. My experience is a little bit like Kylie's in that the men seem to be more terrified of the women than the other way around. But maybe that was just me wielding a stick. It seems to me that equality law issues might be less of a concern if you can demonstrate a genuine evidence basis for needing protective provisions.
The starting point, perhaps, to ask the question. As to which, Cliodhna or Kylie or Sophie, any questions for Sarah before we move to Cliodhna? No. So, adopting Sarah's phrase of big topic by itself, the regulation in sport in Ireland, and Cliodhna Guy, who I think perhaps one of your professional highlights came in February 2017, where you met me. So let's start there as a point and look at the build up to that great day. What was your career in law and then in sport?
I think my career in sport happened before my career in law. So as you suggest earlier, there might be a eugenics program going on here in terms of my parents were hugely involved in athletics and moved into anti-doping in a way here, so had been testing, and I became a doping control officer I think at age 19 or something. But my mum and dad have both been very much involved in athletics, and dad at an international level. So I'm not a sports fan. I don't particularly watch sport, but my involvement and interest in sport has always been behind the scenes in terms of the management, administration, organisation of sport. That's, I think at about 12, I knew that tracks had to be 400 metres plus or minus 4 centimetres, because that was a standard deviation of measurement in tracks in the 80s and 90s, because my father was helping write the book for the IAAF on design of stadiums. And I subsequently went on to qualify as a lawyer here in Ireland in a commercial firm, qualified in the wonderful time of 2008, 2009, where we were suffering from the recession and there were no jobs. And went on to join the FAI, so the Football Association of Ireland, here as a disciplinary manager, and moved into the legal manager role. So the FAI at the time was one of a few federations in Ireland who would have had a legal team. Now, when I say legal team, there was a legal director. I then joined, so we became a team of two. And I learned a lot about football, probably less than I should know and more than I wanted to know, but I really enjoyed it. It was a great learning curve there in the FAI. I moved from there to international boxing, and I moved to Lausanne and worked there for about 3 years and had the pleasure of an Olympics and going to Rio. And then I decided to come back to Ireland and joined what was the Turf Club at the time, since become the Irish Horseracing Regulatory Board. Remember the name of my own company, as the head of legal, licensing and compliance. So that's the short tour of my career until I met Louis, which was one of the major highlights of that, and trying to hear Louis saying names like Uachtarard and the various Irish names we like to throw into disciplinary hearings just to confuse you.
No, that's me. I'm the only person I think who ever found their way to NAS by finally going around to ask, how do you get to NAS? I do get that. That's slightly mean. So you have a lot of experience in regulation in Ireland. And as we go through those sports, you've been involved in amateur sport, international boxing, which is regulated as an amateur sport, professional football with all that and all those difficulties there, and then horse racing professional sport with something of a amateur history. How have you seen the change in the role of the regulator in sports over time?
I think it's not so much the change of the regulator, it's change in sports entirely. We've got moved from the 80s and 90s, very much volunteer organisations, even up to the international level. They were volunteer organisations run by those who've been elected. And now you look at federations, and the majority of federations have a professional staff. And that's been a huge change. Now it's reflective of the increased demands on sporting bodies and on sporting structures, that you now cannot run, or it's a lot harder to run a sports body or sports structure as a wholly a volunteer organisation. Insurance, health and safety, rules, legal challenges, all that has moved on. Now, you have to have a professional staff or a staff there who can devote the time, and it's not, volunteers can no longer be required or expected to run a federation to the level that's required for the athletes, to service the athletes. And
in horse racing, there's a particular problem, isn't there? That perhaps unlike the BHA, British Horse Racing Authority, and before it the Jockey Club, the Irish Turf Club has always had a sort of mixed role of being a semi-statutory body, and Ireland, much to its credit, has a constitution which gives two sorts of rights. You have a right of challenge to following the parliamentary authority. I'm not going to try and say that now, you've taken the mick out of me. And also you've got a constitutional right to challenge. So there's been quite a lot of litigation in Ireland, hasn't there, involving the Turf Club over the years?
Well, we're subject to judicial review. We are, the clubs and the Turf Club and the Irish National Hunt Steeplechase Committee existed as private members clubs. They have been given certain statutory functions under various pieces of legislation. We are still a private company, but we do carry out legislative powers and duties and responsibilities. So we have been subject to judicial review, which changes your landscape. When you're in other federations and you're not subject to judicial review, you still have the fair procedures, you still have the transparency, but you're dealing with organisations and disciplinary bodies who are accustomed to sport. And this, to use the European term, specificity of sport, and that's a specific issue. When you're moving into the normal judicial area, they may not be fully cognizant or understanding of some of the sports factors that we would take for granted in our operation. Now, that said, I understand when people looking from the outside in are kind of saying, well, that doesn't make sense or I don't understand it, but it is a reality of the organisation. And I don't think it's completely different to other industries. Every industry has their special aspects that take certain requirements and are not always understood or fully explainable. Now, it is good for sports bodies, because I remember in football, I often was told things were custom and practice. And the question was usually, well, who's custom and what practice? And trying to get to the answer of those. And it was kind of, well, it's always been done this way. So being able to ask those questions and critically review what we do is always a positive thing. But notwithstanding the fact that we're subject to judicial review, we have a very transparent and robust disciplinary system. And we are very lucky within our organisation. We have a number of members who sit on our disciplinary panels, and I'm lucky, and Louis has been very lucky, at sometimes it's very challenging to sit in front of chairpersons and panel members who make up a vast amount of our judiciary in Ireland. And I have to say, I didn't go down the route of being barrister, and I've had to learn on my feet quite a lot when you're presenting cases and you suddenly get asked about constitutional law and a number of other areas. But we do have like judges who are dealing on a daily basis with criminal, with civil matters, and have a very good understanding, and also who sit on stewarding panels on a weekly, monthly, whatever it is basis at racing, so have a very good understanding of the day-to-day aspects of racing.
Take a spin back there slightly. I mean, the complexity of sports regulation has led some sports to sort of throw up their arms, burst into tears and panic, and other sports to adopt a slightly more professional and legalistic approach. And is the Irish Turf Club moving to the IHRB, it's followed that path, is it?
I would say the movement is was caused by a number of reasons. Partly, when you're a private members club, you have unlimited liability, and that is a reality. So the IHRB was created, and we've moved into all our regulatory functions are under that company. I think for federations and governing bodies across the board, when they're faced with legal challenges, whereas they might have been doing things to the best of their ability or the best of their knowledge, cases can spiral, or cases can escalate before they even realize it, or without the understanding of the full requirements or what they're dealing with. And that would be very frightening for members. And I've seen it, especially when I worked in the FAI. You're dealing with clubs who are volunteers and are suddenly faced with legal letters. And to be fair to them, they don't have a clue as to how to deal with it or how to go about responding. And do they then invest the money in the legal advice? There has been not a reluctance, but a resistance to investing in legal aspects, because when you're a sports body, what your members are looking for you to invest in is sport, and they don't necessarily see the ancillary aspects as being an investment in the sport. However, if we put the structures in place, which we've had here for a number of years, and we're continuing to review and update them, you put those in place, they benefit your athletes, they benefit your participants in terms of you have a clear formatted structure that they can go to and they can use to ensure that they're happy with the decisions coming out. Now, they're not always going to be happy, but at least they can go through a process and say at least they were given a fair hearing and had the opportunity to put their case in front of people.
No, I confess to finding it slightly surprising to be arguing points of Irish constitutional law in front of a former Supreme Court judge of Ireland, coming across as I did from a relatively legalistic backward state of England. But I was helped by you, for which thank you. But
you could say Oireachtas at that stage.
Okay, I'll give it a go. Oireachtas, there you go. Right.
Very good.
Thank you very much. But one huge benefit, I suspect, of having people like Tony Hunt, a High Court judge in Ireland, or Joe Finnegan, former Supreme Court judge who's now retired, and Noel Finlay, is that the integrity of the process is beyond repute, because the integrity of those people is beyond repute. And part of the complaint always about a private law regulator of sport is that they take decisions in smoky rooms over sandwiches. That's what.
No, definitely. We have Joe Finnegan was the former head of former independent chair of our appeals panel. Niall Fennelly, who's a former Advocate General of the European Court of Justice, a former judge of the European Court of Justice, and a former member of our Supreme Court, who sit on these panels and they go through them. Now, we do balance it by also having members involved, and I would be hesitant to move to a panel made up entirely of external people, because there is a benefit in having people who have an experience and understanding of the sport and sitting on these panels who can look at these cases and understand it from the sports aspect, and not, there was always the concern, again, if you're talking about the smoky rooms with the sandwiches, and as you said, all men, we do have females involved as well, Justice Leonie Reynolds and Justice Siobhan Keegan, who sits in the courts in Northern Ireland. And these decisions are made in a very strong way. And you can see in more recent cases, we have moved to issuing written decisions in some of our cases, which are more complex. So to give a better understanding of the process. Now, it is always, it's funny, having sat on this side and kind of presenting cases for a number of years. I had the experience a couple of years ago of chairing a panel for clay shooting. And I sat as a chair, and I silently apologized to every committee member I had criticized or, you know, wondered what they were doing when they sat on the other side of that table, because it's not as easy when you're sitting, when you're presenting the case. It's very clear in your head as to what the decision should be, and you sit on the other side and they're presenting the case to you. It's a different process. But we are very lucky with our members, and also those members who are not legally trained, who come in and apply their knowledge and their experience to sometimes quite difficult cases and come out with very good rationales and decisions, and do it in the best interest of the sport.
I see that, and I very much respect it as a lawyer who does a lot of work in horse racing and other sports. I know less about horse racing than everyone else in the room. I may know less about law than most people in the room, but I sometimes I get by. Anyway, that balance, though, of increasing the legalistic nature of the hearings, how have the defence side, how have they been able to balance up the fairness? Have they started instructing lawyers themselves? Are they doing pro bono? How's it working?
For us, our jockeys do have access to the Irish Jockeys Association, who secretary is a solicitor, and we have other solicitors who work within the area who are instructed. We allow for either representative body, nominee, or a legal representative to come in. I do think there's often a concern, and not just in horse racing, in any sport, that they come into a process and there is a concern on the part of the athlete that if they're not legally trained or don't have somebody in their corner who's legally trained, they're going to have a problem, or they're going to be railroaded. And I think from a regulatory side, I find if we have individuals coming in without legal representation, you do tend to work with them. I find myself giving our case and then sometimes hopping the fence, for want of a better term, to give the other side of the case a bit and make sure that those individuals are having the opportunity to say everything they need to say or they want to say to the committee. And you do try and make sure they're aware this is their opportunity and it's their chance. And you don't have to say it in, you know, very formal legalistic language. You can say it in your own words and going through it in your own words, and very much so. And I've been very conscious of that throughout my career when you're dealing with athletes, to ensure that they have the opportunity and they're given the confidence to say things like that, to say what they feel they need to say. In terms of pro bono panels, at the moment, we don't operate a pro bono panel. I do sit on the board of Sport Disputes Solutions Ireland, which would be similar to your Sports Resolutions UK body. And I know we have a number of governing bodies that would use our functions in their disciplinary process as an appeal or in selection process for the Olympic Federation of Ireland. And we are looking at possibility of pro bono panels, but there's a myriad of issues and concerns that arise when you start looking into pro bono panels, how they're structured and how they're used. But it's not, I don't think, in a lot of sports organisations or a lot of sports structures, you don't necessarily need to have a solicitor behind you. Possibly by having people like me, qualified solicitors, in our structures, we're encouraging it or inciting it, and we are a consequence of actions or legal actions prior to our time. So it does escalate, it moves on. But I think if we can bring an increased transparency and help our participants and have those conversations with our participants before the process and help them during the process, we do our job. And we do our job both for our organisation and for the participants and licensees that are involved.
Well, I see that. Delivering a fair process is part of the job of the regulator, but the regulator needs to protect itself because it's the regulator who's going to be the one who's on the back end of a judicial review. Looking prospectively, I don't want to dwell at all on the welfare issues. You've had, I think, one or two corruption cases in Ireland in the last 200 years. It seems to be a very well-regulated sport. You've had some anti-doping troubles which flared up a bit at the weekend. But one topic that Sophie is going to talk about in just a moment is safeguarding, and it arises in horse racing perhaps unusually in these terms, that both here and across the water, for a jockey to race under rules, they need to qualify in a number of winners to stop being an apprentice, and that means that for a while they're an apprentice jockey, normally tied to a particular yard, and therefore getting rides and prospects largely under the whim and beneficence of either a generous owner or a generous trainer. And is safeguarding something that's on the agenda of the Turf Club, the IHRB?
Safeguarding is very much something that is on our agenda and part of our remit. We have moved in terms, and just in Ireland, you're an apprentice jockey in the flat. The National Hunt, you have some conditional, but they're not tied to a yard or to a trainer specifically. So they operate independently. It's like, in terms of our Garda vetting legislation is tied to the fact that an individual has to be working, or the part of their job, the course of their job is involved in a minor or a vulnerable adult. And I've had the interesting experience in terms of saying, having our Garda vetting bureau saying to us, well, hold on a second, is that the course of a trainer's job? And it is very difficult to work that through. So a lot of it is around the education and training. It's also making sure that that jockeys, and even more so than jockeys, you have stable staff, you have a number of people involved in our industry. It goes quite broader than other sports. They know where to go if they have an issue. We have HRI, or Horseracing Ireland, which is our promotion and sanctioning body. We are separate, unlike the BHA, have a number of support structures in place to assist people. And we've also moved in terms of our jockeys courses, bringing them in and doing a lot of education and doing like mock inquiries, because it's all well and good that you're saying you're a jockey and you're able to ride a horse. But if you're on track on a day and you're brought into an inquiry with a number of stewards looking at you and asking you questions as to why you decided to make that maneuver or decided not to make a maneuver in the middle of the race, how to deal with that and how to answer those questions. And I see safeguarding as a very broad aspect. It's empowering and teaching all those involved as to how to deal with the process and how to be involved in the sport on a wider basis.
Thank you. Now, does anyone have any questions for Cliodhna before I turn to Sophie? I
was just going to quite meanly kind of jump in on my theme, Cliodhna, and just ask about your experience of women, particularly in the horse racing sport and the industry. I mean, I don't know, I don't want to put you on the spot, but I mean, what in general terms is your impression of how women want to be treated in horse racing? Do they just want to be treated exactly the same as the men, or are there some respects in which actually they'd like different treatment in order to achieve what they consider to be kind of full equality? How does it manifest really for you guys?
I think Rachel Blackmore gave a very good answer after one of her races in the UK when they said, you're the first female jockey. And she goes, I don't feel male, I don't feel female, I'm a jockey. And I think that would carry through in the sport, to be honest. There are quite a number of women involved at varying levels. Like if you look at internally here, I'm the head of legal. Our chief veterinary officer, head of anti-doping, is Dr. Lynn Hillier. We stole her from the UK, but we kept her. And then our chief medical officer is Dr. Jennifer Pugh. So, there's quite a lot of women represented at our level. There's quite a number of female trainers, and there are more and more jockeys. And to be honest, being a jockey, whether you're male or female, is tough. And it's a vocation, as I would say, as opposed to something you pick up on any one day and decide to do. But majority, they want to be treated the same. They want to have the same standards, the same opportunities, and to be regarded on merit as opposed to anything else. Now, it is hard. Are we starting from a lower rung and we have further to work, and it's all that? But I do think if you look at it, a lot of the women involved in this, they do a huge amount. Like look at Mrs. Jessica Harrington, trainer, has a huge number of runners and winners and a lot of success across the board. And Rachel wasn't the first. She follows in the footsteps of Katie Walsh and Nina Carberry, who've all blazed a trail through it. And then in the administration side, if you look at the number of racing secretaries and everything else, it's very much female-led and it's very strong. We're not always the ones to look for the creditor, to look for the limelight, but they are working and very strong in it. And it is an equality situation. They want to be treated the same and have the exact same standards and opportunities.
I suspect, and you put me right, and I appreciate the weakness of my position and the size of my feet on this topic, but if you started suggesting to women jockeys that they should spend longer off every time they had a concussion than men, they might swear back and say, we want to get out and ride some money and earn some money sooner, and you're being unfair. It would be a very difficult topic to broach, probably one I'd avoid. I might put Sarah up for that. Right, I'm going to jump off. Thank you very much, Cliodhna. I'm going to introduce Sophie and back to the topic of safeguarding, and in particular the question of how to deal with taking evidence from people who are involved in safeguarding cases. Sophie, over to you.
Thanks, Louis. And in the last sort of few minutes of the presentation part of this talk, and subject to all the questions that I hope will flow from the attendees, as Louis said, I want to talk about safeguarding in sports disciplinary proceedings, and specifically vulnerable witness evidence. As Cliodhna has touched upon in terms of critical review of sports tribunal processes a few moments ago, I think there is increasing awareness, and as a consequence of that awareness, demand for a more proactive witness safeguarding measure or measures protocol to be present and put in place in sports tribunals. And I think that's born of a growing understanding that the duty to protect and promote the safety of children and adults at risk is not just in preventing the abuse or the harm itself, or even in developing proper structures to allow for the proper reporting of abuse or the timely reporting of abuse, such as those that were recommended and ventilated in things that came up in the football, for example, the Sheldon report or the Geeky report, which were relating to historical sexual abuse in football. But that duty and those obligations of safeguarding must go right through to the investigation and disciplinary phases, when victims and witnesses are required to give evidence against the accused or the respondent. And I think that appreciation is growing amongst professional bodies, that issues such as the nature and extent of questioning of vulnerable witnesses needs to be evaluated in advance. That needs to be a topic that is considered substantively rather than in response to specific submissions made by an advocate in any tribunal in the moment. And I think that there is a growing understanding that the effect of giving evidence against your abuser or against the respondent and being the subject to questioning needs to be acknowledged, and steps that are taken. There has been a lot said in the last sort of 5 or 10 years in terms of victim support during the initial reporting stages. But I would say to you that is really only half the battle, and that the framework is needed to carry through to the outcome stages. And these points that I'm making are not just a question of compassion for the victims, but that a failure by any tribunal to properly engage with these issues, which surround a witness giving their best evidence, exposes parties to real risks of prejudice and improper or unsatisfactory outcomes. And it's been shown time and again across both criminal and civil proceedings that to fail to do so, to fail to engage with safeguarding in terms of witnesses' evidence, wholly discourages witnesses from engaging in proceedings, and really means that the whole process of safeguarding and guarding against exploitation of victims and allowing abusers to walk away falls at the last hurdle.
Can I just ask a question?
Yeah.
I did a case last year, and it really horrified me when it was a group of young men who'd been involved in a safeguarding concern. And the rules of the particular sport hadn't put in place a framework for taking their evidence in any particular way. Yeah. And the representative of the athlete was interested in effectively what the French might call a confrontation in front of the tribunal. So that's the problem. And trying to explain to someone who you're taking evidence from that may happen must be the most terrifying and horrible of thoughts. So what's the way forward, and what's happening to get out of it?
Yeah, so I mean, I think one of the reasons why I've come to notice this, and probably you as well, is that I come from I initially trained in the sort of the criminal sphere and the criminal courts, and they for some time have had fairly established frameworks and obligations for tribunals, for the judges, or in the case of sports disciplinaries, for the chairs, that there would be an obligation to undertake various safeguarding activities. And if you look at, for example, the FA, which in every sort of other regard is often considered to be quite a progressive disciplinary procedure structure, they seem to be a regulator that is more advanced than many. They still have a very skeletal framework in place that leaves a huge amount of discretion to the chair, and often relies upon the advocate or those who are representing the witnesses or the complainants or the victims to, of their own motion, suggest various safeguards and frameworks that may protect or allow the witness to give their best evidence. So, for example, in the FA, they still don't have any consideration for remote evidence or pre-approved questions. Questions are put through the chair, but the chair doesn't necessarily know where that series of questions is going, and it might lead to improper cross-examination. And equally, I think it's still the case, and correct me if I'm wrong, but often the victims and the accusers, or the complainants and the respondents, are sitting side by side in tribunals when the victim is giving evidence. And so they are in many respects hugely behind the curve, in my view. But you asked a moment ago about where's the forward motion going, where's the prospective change, and I think one example of that sea change is in the sports resolution, recently published investigations guide, and also with templates as well, which was to go out to the national governing bodies, the safeguarding panels and interested parties. And that was very much advocating and providing a framework towards proactive considerations for witness evidence in sports disciplinary proceedings. And I think if you go, for example, if you were to go to the procedural rules that Sports Resolution have come out with in 2021, their section 10 is a section that is exclusively addressing evidence and the evidence of children and adults at risk. And the recommendations and expectations that they set out are, for those that may be familiar, are far more akin to those that you would see in criminal courts. So, for example, they advocate specialist vulnerable witness training, something called achieving best evidence interviews. So that's often where there are sort of specialist arrangements made to ensure that you achieve the best evidence from the complainant or the victim, such as pre-recorded evidence or recorded evidence which is remote, giving evidence behind screens, so you don't have that proximity to your respondent, which can often be a massive impediment to giving of basic accounts as to abuse, for example. And also there's entire passages which are advocating towards much more proactive oversight by the tribunal of the questions that are asked, the remit of those questions, the style of cross-examination, and the way that you can, as you were talking about, going after sort of a badgering of the witness or some sort of confrontation. So I think we are moving in the right direction. But when you contrast that, for example, with the International Olympic Committee, the UNDOC, the Court of Arbitration for Sport, or even UEFA, to name just a few, have for years had special measures, including witness anonymization and frameworks of whistleblower protections for those reporting or giving evidence in relation to match fixing and doping, which is obviously a very different category of vulnerability. But this lacuna is very deep rooted and goes even to civil procedures where there is no specific rule in relation to vulnerable witnesses, and the existing rules have already been criticised heavily for being passive and inadequate in that regard, which is very much mirrored, I think, in the sports disciplinary tribunals. And I think if one looks at for example, the Geeky report or the Sheldon report, which is obviously just only focusing on football, but there is very palpably, I think, a change in people's perception of safeguarding, of the positive obligations that are inherent in the sporting bodies and all those that interact with young athletes and those who may be vulnerable. I mean, you spoke with Cliodhna a few moments ago about the sort of inherent challenges of the way in which jockeys come up through to their seniority, the way that they rely upon a huge amount of discretion, which gives rise to the risk of abuse and exploitation and things of that nature. And so I suppose what I wanted to bring to the fore today was that there is increasing awareness of and literature going towards safeguarding. But I think that safeguarding in the tribunal setting, in the the giving and taking of evidence in respondent and complainant environments is still lagging behind. And there is a huge amount of discretion that is still available to all participants, which can give rise to real failings, I think, in terms of safeguarding those who are giving evidence. And so in that regard, I would say that there is still some way to go, and it relies upon many of us who are in attendance today, who are participating in any sort of tribunal setting, to engage with the spectrum of special measures considerations, such as those that were recently published in the Sports Resolution publication, and take an active role in guiding the tribunal towards far greater engagement with safeguarding. And I think, as I said before, this is not just a question of protecting the vulnerable in sport, but it's also about advancing and protecting the integrity of the sports disciplinary process, which again is something that Cliodhna has spoken about in terms of the sort of arbitration aspect. But it is a fundamental tenet, I think, of a functioning disciplinary body, that it is seen to be protecting all of its participants against prejudice and against wrong outcomes based upon a failure in procedure. And so, although this was a slightly different lean and far less interesting than talking about going to the Olympics, in my view, and particularly looking at the various different ways in which there is interaction with the judicial processes, the way that there is judicial review and things of that nature, I think there is a far greater call now for the safeguarding, which has been much more publicised in terms of the early stages of preventing and reporting. The latter stages of this process need to be given greater focus and consideration. And that is all I'm going to take off of your time.
I think my experience with the various disciplinary tribunals is, whilst they haven't picked up on, as you obviously have, the learning that can be drawn from criminal courts and from now Sports Resolution's work programme of how to bring in sensible rules. Most tribunal chairs will reach a reasonable conclusion and will work towards achieving that. And I don't think there's any criticism of the FA and the way it deals or has dealt with recently with taking evidence. The problem is that the rules are behind the curve, and there's not the reassuring structure for anyone who either looked at it beforehand to know where it's going. I think that's more of a problem. And if it's thought out in advance, that great phrase that Judge got in trouble for writing down a piece of paper and handing to a barrister, prior preparation prevents disappointing performance, I think is probably the neutral way of putting it. Thinking rules through in that way and thinking the issues of equality and how to make life easier for people ahead of time before it becomes an issue of litigation is a good plan. But that was my comment.
It's also a question of if you're trying to encourage or reassure complainants and those who are giving evidence in that kind of forum, you don't want to say, oh, we'll do our best for you in the day and let's hope for a sympathetic chair and one that is fully abreast of the obligations which he should want to embrace. I think if you had structures in place, then that would be a fundamental reassurance throughout of the manner in which complainants and victims will be treated in the tribunal process. So I think, again, it's about that, not just the fact of it being done, but that transparency of knowing that it will be done.
I agree. Getting someone, I mean, the concept of having achieving best evidence, either video or written interview ahead of time is just alien, I think, to most of
I think a really basic example is when you think about sort of really, if you have really serious allegations of sexual abuse or things of that nature in a disciplinary tribunal in a sports setting, I think they allow sort of a couple of hours to sort of ventilate that. In a criminal setting, or even I think in a civil court, that would be given over hours to the point of days, and in some circumstances weeks. And so I think there needs to be sort of a recalibration in line with the reports of the gravity with which these issues need to be dealt with and being seen to be dealt with properly.
And Sophie, sorry, just to ask, are sports bodies the right bodies to be dealing with those kind of abuse claims? And it's one I struggle with myself in terms of there is a disciplinary factor. Now in Ireland, if we have a complaint that relates to a child protection issue, we have to refer it to the appropriate statutory authorities. And we have to step out of it. We don't take, there may be immediate action taken in terms of a suspension of somebody, or depending on the sports, or dealing with that. Yeah. But I have to say, I struggle from a sports perspective in saying if those organizations, because of the fact they're not set up with the appropriate powers, with the appropriate expertise and everything else, to take those cases, and are they the right one? Because you often, like, if somebody is found guilty of a child protection issue, then it's very easy for federations to say, okay, fine, you're guilty. You're no longer involved in our sport. You're removed from the sport, and you're not going back through the history. You don't. It's not up to them to review the case or decide right, wrong, or indifferent. It is, you're guilty, and therefore you're out of the sport, and that's it. And I do wonder if it's not fair, but if it's the right place, because you do risk, as you say, further damage to individuals, or wrong decisions.
Yeah, no, I mean, I agree. I think it's a really difficult one, because you can, well, as Louis sort of emphasized, there's no suggestion, for example, with sort of FA disciplinaries that the chair is in somehow sort of circumventing willfully obligations towards victims or safeguarding duties. I think it's that lack of clarity of where do our responsibilities lie, and what is the remit of that duty. For my part, I can well sympathize and see that sort of look of despair when someone that is built to deal with entirely different issues is suddenly having to deal with historic abuse claims. It's a wholly different, kettle of fish and expertise, as you say. But I think, again, it's just a question of promoting a necessity for clarity, for transparency, so that I think a lot of the issues that come is where people's expectations of what is going to take place, what duties are going to be undertaken, what powers does a tribunal have. I think a lot of it comes down to understanding what can take place in different forums, to know better the limits of that. And I think that's one of the bigger problems, I think, is that lack of transparency about what can be achieved.
We've had a comment from Jenny Smith, who works, I know, in the field of safeguarding, and she's running a workshop, she says, on the sports resolution type program, and saying how welcome it is in sport, but making the point that if their sport is not itself able to maintain a sort of cadre of professional investigators, there are external bodies now who provide the service. I appreciate there are funding issues. Maybe they can be dealt with centrally. I think probably the hardest cases are those where complaints are made and the complainants, for whatever reason, invariably, very understandably, don't want to involve the police. And then the sport is put in a terrible position that they've contacted LADO and they've contacted external agencies, social services, whoever. No one is actually going to pursue an investigation, and there's no one left to do so but then the sport. And then the sport really has to, otherwise it's going to find itself in the great vacuum of finding itself, perhaps as Kylie should be, but in a very different context, on the back page of the Sun some years later, saying what the hell happened. I think the days where you can stand back and expect the Gardaí or the NIPS or the police service in Northern Ireland, it's not the NIPS, it's the police service, or the British police to do something about it, are well over. You've got to crack the whip. Right.
Yeah, I was gonna jump in there, Louis, and make pretty much the same point. I mean, my experience has been that the most difficult cases are the ones where there isn't sufficient evidence to mount a criminal prosecution, and particularly in circumstances where the complainants are perhaps unwilling to actually kind of go on the record with their complaints as well. And then the governing body's left in an almost impossible position where they've probably got a policy which is risk-based. In other words, they've got to then make a determination based on what the risk this individual poses in a safeguarding sense. But they don't actually have very much by way of concrete evidence about previous actions. And I think linked to that is something that Louis already touched on, and so Sophie as well, which is that I think a lot of governing bodies focused initially quite rightly on prevention and mitigation in safeguarding abuse cases, and obviously then you've got the situation where somebody's got a conviction and then the sanction can follow based on findings made by another tribunal. What's kind of coming through now are those middle cases where they haven't got the findings of some other investigative body to rely on, and I think they're going to be the most difficult ones, and they're not going to get resolved until the kind of measures that Sophie's talking about are in place, because the complainants are going to kind of make their complaints and then they're going to melt into the background, and then you're going to be left with this situation of having a risky individual on the face of things, but no real way of proving that in front of a tribunal to get a finding. I don't think there's a silver bullet, but I do think that if there were clear rules about protection of witnesses, that might go some way. And then also, like you say, Cliodhna, some investment in actual investigation, because I know governing bodies invest a lot already in, say, doping and integrity investigations, but it looks like safeguarding is another field where those same kind of investigatory investments are going to have to be brought to bear. But that's just my kind of two penneth based on what I see from those. I mean, pick on Kylie for a minute. Have you had any dealings with these kind of safeguarding things in wearing your kind of regulatory hat in touch rugby?
No. I think probably because it's such a small sport in this country that hasn't cropped up. But I can imagine it's going to at some point.
Well, I hope it doesn't stay such a small sport forever, because it sounds like a lot of fun. I think my touch rugby days are behind me, as most of my sporting endeavours are behind me, and I see the time, I'm sad to say. So can I say goodbye to everyone, but thank principally our guests, Kylie and Cliodhna, for giving up their time and their insights into things that us lawyers never really actually get to do other than stare at books. Thank you very much for your time. Sarah and Sophie, thank you very much for your wisdom. I hope to see you all in the near future. And can I say of my panel, thank you very much indeed. Goodbye.
Thank you, Louis.
Bye. Thanks, everybody.
Bye.